Yes, please. Call the list.
Item number 1 to 8. May I please, Your Lordship? Before
Yes.
that, Lordship, item number 15. I have just come today. I received the appeal memo on Sunday. So today is the date. So I have just come. I need little bit of time to file the wakalatnama and a reply.
Are you mentioning about notice?
Lordship, I received the notice, Lordship. Only on Sunday I received it. Because it went to Bomdila, and from Bomdila, it came back to me again. It was sent back to me by
You're
the
coming
party.
from Calcutta?
I'm coming from Guwahati, Your Honor.
What is this matter about?
It's an arbitration appeal.
37 appeal, my lord.
37 appeal.
Against section 34 court's order, my lord. My lord, we challenge the award, my lord. Arbitration
Award.
My lord. We challenge the award. Learned court below upheld the award, more or less, my lord, except one claim, my lord, and upheld the remaining claim. Against that, we've come.
Then you have to deposit the awarded amount.
50% has been deposited in the trial court itself, because simultaneously they filed execution petition, my lord. The deposit is
50% was deposited by Union of India. Execution we have not filed, Your Honor. Stay is granted, and I have not filed also.
So we can hear out the appeal.
my lord.
What do you say? On the 50% deposit?
That will be very less, Lordship. 50%. Actually, that area, Lordship, it will
You see, the matter is item number 15 in the list. You cannot say that it is in the list. I have come today, so you have to take up the matter.
No, Lordship, I
So
need time
there,
today.
we will list the matter
Lordship.
for consideration. We will give you liberty either to come here or to do it online, whatever you feel like.
Lordship.
Would it be convenient for you to come here? Because we encourage physical hearing.
Yes, Lordship, even I support physical hearing. It's just that
But
if
when?
Union of India does not take too much of time, last day had filed before the trial court in the year 2018, and it was disposed of this year, Lordship. Adjournment, lastly, trial court below allowed me to come online. That you need not come on every day.
My lord, next day, whenever the matter is fixed, I'll argue, my lord. I'll not take any time, my lord.
When would it be convenient for you?
Lordship, I need my client's signature. He is presently with his wife in Mount Abu. He will be coming in 10 days' time. I just need his signature.
Subject to the, you're a learned advocate, subject to the undertaking to the court that you will file a wakalatnama, we can entertain.
Yes, I will file it, Lordship. I'll file
Yes.
it.
$14th or 18th, what would be convenient for you?
14th of?
This month?
14th August.
Yes.
No, Lordship, let it be 18 then.
All right. List this appeal on 18th August at the top for admission and consideration of an interim order. Liberty is given to learned advocate for the appellant to file a wakalatnama in the meantime, full stop, in case a wakalatnama cannot be executed during this period. Such liberty is granted subject to the undertaking to file a proper wakalatnama by 29th August.
Much obliged.
Yes.
Deeply obliged.
Item number 1 to 8.
Please, my lords.
May it please your Lordship.
Lords, towards the directions passed by this Honorable Court on 7/8/2025, lords, a sum of rupees 50 lakhs has been paid by us, and my lords, the electricity connection was restored on the 8th of August, my lords.
Yes. As assured by Learned Advocate General.
My lord.
One day time.
But the only issue is, my lord, there are certain things which I couldn't place through VC, my lord. What has happened, my lord, that there is a tariff order which has been passed by the competent authority, commission, my lord. In terms of the tariff order, my lord, in terms of the tariff orders, all consumers were directed to pay 9 installments. Almost all of them have paid, my lord, except there are 4, my lord. If I can give the chart of pending amount and the amount paid by them. So, Your Lordship, first is Pioneer Carbide Private Limited. And in the first matter, there are 2 appellants before Your Lordship, Pioneer and Mathan, my lord. So, Mathan has paid the amount. Pioneer has not paid single penny because direction was to pay from December of 2024, my lord. December of 2024. From December of 2024, my lord, up to June, 6 installments were to be paid up to June, my lord. And if Your Lordship will see the column first, Pioneer has the total outstanding amount of the arrears was 4,04,09,000 rupees. And only pursuant to Your Lordship's order, 50 lakh has been paid, my lord. Pioneer is in default, my lord. And one more thing, my lord. Similarly, RNB Carbide, my lord. RNB Carbide has paid 2,25 lakh rupees. 36 lakh rupees is due, my lord. Green Valley, my lord, has paid 1,50,00,000 and then 21 lakh is due. And then RNB Cement, they have paid about 94, 15,81,000 is due, my lord. So far as the first matter is concerned, my lord, in other, there, if Your Lordship will kindly see the cause list.
Causes.
It is a common electricity connection.
No, my lord, it is separate electricity connection.
All have been disconnected.
All have been disconnected earlier because
They were
all
disconnected, my lords.
No, my
They
lord,
were
they came
paid.
forward and paid the amount. We did not disconnect. Those
Yes,
who
that
did
is what they said. We are not asking for an interim order because the line
Is
is
restored.
operative.
Yes, operating. So far as the others are cases are concerned, they are required to pay current as well as arrears in terms of tariff order of the MSERC, my lord, Meghalaya State Electricity Regulatory Commission. Pioneer is the company, my lord, and the Pioneer, I am very sorry to say, my lord, Pioneer, if Your Lordship will see the additional affidavit filed by learned friend.
No, but what is the subject matter of challenge? In
The subject matter was challenged by the tariff order passed by the commission before the learned single judge. They took the ground that the commission has no power to.
Retrospective.
No, it's not a retrospective.
Two issues, my lords.
I
One
will
is
explain, my lord. There are two
One
grounds.
is retrospective. One is, my lords, that the commission did not have the power to recall its own orders.
So on that ground, my lord,
Or revise its earlier orders.
My lords.
you know what has happened, my lord, that there was a tariff order passed on 6 June of 2024 by one member of the commission, whereas the matter was heard by 2 members, my lord. We approached this honorable court saying that the matter was heard by 2, one could not have passed the order. Then this honorable court granted us liberty to go back. We went back to the commission recalled the order, my lord. And after recalling the order, it passed a fresh tariff. Recall order was challenged by the association. That is 23rd August 2024 order. After the recall, my lord, on 24th October 2024, the commission passed the tariff order for financial year 24-25 because it's a multi-year tariff for 3 years. That 24-10, my lord, the association came before the learned single judge saying that the commission had no power to pass this order. It was without jurisdiction. That was the only ground taken by the association, my lord. Learned single judge examined in detail and found that there is an alternative efficacious remedy under Electricity Act, that is under section 11 of APTEL. You can approach the APTEL against the order of the MSERC if you are aggrieved. Learned single judge, while examining the matter, made certain observations in regard because issues were raised on the merit as to the power of the commission. The learned single judge by exhaustive lengthy order dealt on all these aspects and held that you have the alternative remedy before the APTEL under section 111 of Electricity Act. That was the finding of the learned single judge. The entire matter was heard in batch. Pioneer in the first matter, Pioneer said, no, we have also raised the ground whether the commission has the power to impose tariff from financial year of 2024 to 25 because tariff order has come into effect from 24th October of 2024. The commission has no power to impose tariff from 1st April 2024. This was raised by them in review, my lord, saying that we have a review. Learned single judge dismissed the review, saying that no such argument was advanced, and learned single judge dismissed that review also. That review order is not under challenge before your lordship. After filing of the review, my lord, they filed a separate writ petition against the order of disconnection, my lord. That writ was also dismissed, that of disconnection writ was also dismissed, and that order is also not under challenge before me. So the issue before your lordship is, in my humble submission, whether the finding of learned single judge as to alternative efficacious remedy under 111 of APTEL, under 111 of Electricity Act is made out in this instant case or not. That is first, my lord. Secondly, the issue is, my lord, whether tariff orders passed by the commission after hearing the parties, all these parties participated in tariff proceedings, my lord. And the tariff orders are passed, my lord, under the regulation framed under Electricity Act, which is called multi-year tariff regulation. In multi-year tariff regulation, requirement is that it will be for each financial year, my lord.
Exactly.
So the question is, my lord, what they are asking from your lordship is that stay the areas in terms of the tariff order, my lord. All parties have paid except Pioneer, my lord. There are some minor.
No, when was this order by the one-member bench passed?
5 and 6 June. 5 and 6 June,
5th and 6th of June, 2024.
2024. That order was recalled on 24th of
23rd August. That order was recalled. Show me the cost list. Taking a print of the cost list. Item 2.
And a fresh order was passed on 24th of October.
October.
24th October. Multi-year tariff from financial year 1st of
Making it
April.
Effective from 1st of April 2024.
Because what they are saying is that if there is a delay in passing the order, therefore I will pay from the date of the order. Whereas in the regulation, my lord, it is very clear that it has to be from financial year. And there was no challenge before the commission, my lord, on this issue. Not a single, even commission's entire order of 24th October is not before your lordship. That order has also not been placed, my lord. Only 2 pages of the orders have been placed. And even, my lord, they have not filed the order of the learned single judge, whereby they went against the order of disconnection, and that order has also not been challenged before.
So that's been filed by way of a third appeal, my lord. That's not connected with these matters.
My lord, that because they are seeking a stay, my lord, and against disconnection.
One minute.
I'm sorry.
After.
My apologies.
After this was challenged in the writ.
Writ, my lord.
24th October.
No, there are two petitions, my lord. There is also duplicity. What has happened that BIA is a Burning Heart Industries Association, is an association of all the industries, including some of the petitioners which are before your lordship. They approached the writ court challenging the order of 23rd August 2024 only. There is no challenge to the tariff order by association.
If I may.
There is no challenge. There is no challenge to the tariff order.
In item 2.
Challenged by BIA, Burning Heart Industries Association, my lord, which is also appellant before your lordship. That is item 2. Burning Heart Industries.
It is not one of the 4 in the chart.
It is because it is an association, my lord.
It's an association.
Association. But now association filed the case and individual members also filed the case, my lord.
After the 24th order came into being, my lords, on the first week of
Mr. Paul, we will give you an opportunity immediately.
I'm sorry.
Yes, 23rd August.
23rd August, my lord, the Burning Heart Industries Association, which is the association of all industries, challenged this order of 23rd August by way of writ petition, my lord. Then some of the members in their personal capacity also challenged the order, and the first matter before your lordship is Pioneer. They challenged the order of 23rd August and also challenged the order of tariff order of 24th October, my lord. The entire argument, the both Burning Heart Industries Association was a lead matter, along with the Pioneer Carbide, my lord. I will place the order of London single judge.
So it was dismissed on the ground that there was an alternative remedy.
Yes, ma'am.
What was the date of dismissal?
This was the order passed on 6th. This was the passed order on 22nd June 2025, which is in appeal before your lordship.
And why was the review made?
Review was made by saying that they have also urged a ground before London single judge that the tariff order should not have been made applicable from 1st April 2024. And that was not considered by London single judge. London single judge said it is an alternative remedy. All these issues are before you can take up before the appellate. And London single judge also held that this was not argued.
So when was the review dismissed?
It was dismissed on 18 July 2025, my lord. And after this, my lord, there is one more development. If your lordship will see, they filed an independent writ petition, my lord, in supplementary affidavit challenging the notice of disconnection.
No, in the main writ.
Separate writ.
No, in the main writ, were affidavits filed?
Yes, my lord. And we took the ground that the writ petition is not maintainable on the ground that there is an alternative efficacious remedy under section 111 of the Electricity Act, which clearly provides, because this is a technical matter where fixation of tariff requires a lot of technical inputs, and therefore there is a specialized agency, a body created for the purpose of examining, because this is aggregate revenue realization for entire industry, my lord. And based on the tariff order is passed, my lord. So therefore, London single judge, and referring to the various judgments of the Honorable Supreme Court, where it was held that the remedy is aptel. A statutory remedy is aptel. So therefore, you go before the...
No, at this stage,
Yes, my lord.
subject to correction by you and Mr. Paul,
Yes, my lord.
after having invited affidavits
Yes, my lord.
and put up the writ application for hearing,
Yes, my lord.
this alternative remedy point
No,
cannot be
that-
taken unless, while deciding the matter,
Yes, my lord.
the court finds that the facts are so complex that the court cannot do it and relegates it.
No, my lord, what has happened, because here the practice is ordinarily affidavits are invited on the very first day on the maintainability, my lord. If I can show the issues.
No, but according to the kind of law that we know, it
Yes,
has
my
to be
lord.
decided right then.
No, my lord.
At
so-
the threshold.
No, my lord, the issue, if your lordship will see, the issue was as to I have raised the ground of maintainability, my lord. Now, if my entire argument was on the maintainability, and the entire writ has been decided on the maintainability,
No, it's
not
not.
on the merit, my lord. If I take your lordship to my arguments and the issues framed by London single judge, my lord.
Well, if I may, before my learned friend proceeds any further, today my lords had directed that these figures be given, which he has been kind enough to give, my lords. Pursuant to the orders that fell for my lords, my lords, we have made the deposit. There's reconnection of electricity. Your lordships have admitted these series of appeals, my lords. If I may only pray, we can have the paper books prepared, and my lords may hear us on the entire issue. What my learned friend is submitting, my lords, para 35 of the judgment, the learned single judge, my lords, goes into the merits of the matter, decides that the orders of 5th and 6th are non-est in law. It's a finding, categorical finding at para 35. Once having done that, my lords, could I have been relegated for alternative remedy? What
And
baffles?
the review application was dismissed on what ground?
Review says, my lords.
Review, they
in the
said-
review, they
in
say,
review,
my lords,
one
the
of-
matters are pending in appeal before my
No,
lords.
my lord, no, this is not correct. In
Well,
review,
I'll
my lord,
point out.
I will.
I'll point out the order of
review,
review.
my lord. In BIA filed the review also.
No,
and
BIS
it
review was withdrawn.
and it was withdrawn when it was pointed out that there is nothing. Then Pioneer filed the other. My lord, what is happening
Para
in this
8
case,
of the review
that these
application,
two
my lords.
the one, Pioneer is part of Burnie Hart Industries Association. It is...
You see, Mr. AG, 2 points are involved.
Yes, my lord.
One is retrospective tariff, so to say, as they are saying, from 1st April.
My lords.
You are saying that if there is a yearly tariff policy, so in October, they could decide the tariff from April
Yes, my lord.
2024.
Yes, my lord.
And the other is that the power of the two-member bench to alter, revise or modify.
Recall the order passed earlier.
Yes,
So if these are the 2 points, the writ court can decide.
No, my lord. So the writ court has basically for these remedies also, my lord, because one is because all these orders, my lord, are of APTEL, where the APTEL has, because these are the regulations
Well,
framed
will
under the Electricity
satisfy
Act.
your lordship?
These are the regulations framed under the Electricity Act. How the tariff orders are to be passed, how these matters are to be conducted, hearing is to be done, and therefore there is a statutory remedy provided to the parties.
Not
my lord.
to this extent.
Now, my friend says not to the
Well,
extent.
as a matter of
extent-
fact, para 8 of the appeal, the paper book which is there before my lords at page 452, the review
I'll-
court specifically says, and I'll read my lords. Furthermore, as the entire judgment of 2/6/2025 is currently the subject matter of 7 writ appeals which are pending consideration before the learned division bench of this court, no case for review has been made out and the instant review petition stands dismissed. So we've been relegated. The court makes a finding that your appeals are pending, and my lords have admitted the appeals. I am only praying my lords may hear the entire matter.
My lord, I have
Whatever arguments
no,
they
I have
have-
no issue, my lord. I am here before your lordship. Your lordship may hear me on the final, admit the appeal and hear the matter. I will satisfy your
Appeals
lordship.
are already admitted by the last orders.
And then we will file after filing of paper books. Your lordship may hear this matter. I have no issue on that. But only issue which I am trying to point out at this stage, my lord, that if the tariff orders are not being complied with some of the industries, my lord, because they have filed some writ petition on some cases, my lord, because ultimately our revenue is dependent on they are using it, they have used the power and they are not paying
I've
the
used
amount.
the power, I've
and
paid for
Pioneer
it.
is the guilty, Pioneer is the biggest, because 4 crore rupees amount was due, it did not pay single installment.
Because there was an
December.
interim order.
There was no interim order.
My lords have recorded in the last
No,
order.
interim order is only to disconnection.
It is,
My lords, there was an interim order of stay dated 21st of January 2025.
my lord,
That order is on record.
and
I'll
I
place it
asked
before your
a
lordship.
question to myself.
It
my lord.
says-
What is Mr. AG, what is this amount due, second last column?
Second last column is,
After
my lord,
payment, my lord, what's the
50,
differential
if your
amount?
lordship will kindly see, first is Pioneer Carbide. The total tariff differential amount is 5 crore 14 lakh 34,000. This was to be paid in 9 installment, my lord. So the 9 installment became due to till 31st July. So 9 installment comes to 4 crore rupees. Out of 4 crore rupees, no installment was paid, 0, my lord. 50 lakh pursuant to your lordship's order, it was paid, my lord. And after deducting this 50 lakh, the amount becomes due from Pioneer is 3 crore 50 lakh rupees. So no amount was paid. 7 installments was to be paid till June of. Since
What is
December.
the installment amount for each company?
Each installment,
It's
my lord,
different, my lords. In my
because-
case, Pioneer is 50 lakhs.
And
Which
the
your
others?
lordships have directed us to pay, we paid.
No, no, others?
the total amount due is 5 crore 14 lakh 34 divided in 9 installment, my lord. This was in 9 installment. If your lordship will see, as per bottom of the page, after director of MECRC, the tariff difference amount is being billed in 9 installment starting from December 2024 due to non-compliance payment installment due. The consumer disconnection was issued in the May of 25 and served in the month of June 25. Up to June only, and now installment becomes so total amount payable by Pioneer in 9 installment is 5 crore 14 lakh 34,000. That is till for December, starting December, my lord, they have to pay 9 installment. And till June we have the figure, my lord. Till June it was 4 crore rupees, out of which 50 lakh was paid, 3 crore 50 lakh was not paid, my lord. So far as the RNB Carbide is concerned, it was total 3 crore 37 lakh 39,000, and 6th installment became due 2 crore 62 lakh 41,000, and they have paid 2 crore 25 lakh rupees. The 36 lakh is due from RNB Carbide, my lord. Green Valley, my lord, 2 crore 20, they have paid 1 crore 71 lakh. At 1 crore 71 lakh was due till June, and 1 crore 50 lakh they have paid, 20 lakh fund is due, my lord. RNB Cement, my lord, is 1 crore 42 lakh 35,000, my lord. this was 1 crore 10 lakh was due, my lord. They have paid 94 lakh, 15 lakh. So these are the only 4 defaulting industries before your lordship. Others have paid, my lord. Others have been paying as per the
What
MSCRC.
is due is 4 crores 23 for all the.
Of all 4 industries, my lord.
Put together, my lords, is
All
4.23.
and major payment is required to be made by Pioneer Carbide Private Limited. It has not paid a single installment. It paid 1 installment, 150 lakh rupees.
I am only making
Installment is ordered by the commission.
A commission, my lord.
originally by the
MSCRC.
commission, my lords, and then, my lords, your lordships have directed on the last occasion.
How
That
much-
order of the commission was stayed by the High Court by order dated 21/1/2025. That order is at page 551 at item number 2, my lords. The
So
order
onwards-
reads, my lords, it is directed that interim the tariff difference between 1/9 installments shall be put on hold till the next date. But however, the writ petitioner is directed to deposit the amounts for the current bills. Current bills we have paid. There is no due on current bills.
And my lord, after
And
that,
that order
3
continued
rounds.
until that
3
order.
rounds, my
If I
lord.
may,
Three-
just-
three.
my learned friend has taken enough time. That order continued up till 2/6/2025, till the dismissal of the writ petitions. Thereafter, my lords, the review was filed. There was an order of no disconnection. Thereafter, my lords have passed the order. On the
And
last
my
one.
lord,
What
they-
is the current installment payable?
My lords, it was 50 lakhs. We've paid it. It was 35 lakhs. Your lordships
they
directed
have
us
to
50
pay
lakhs.
3 crore 50 lakh rupees, my lord.
No, that's the total.
35 lakhs according to the commission's order.
My lords, your lordships record that.
That order is not stayed.
Not
35
stayed.
lakhs.
Not
Not-
state.
not
My lords, your lordships told us that
35 lakhs for each company.
No, my
it's
lord.
different for different companies.
Different dues, different amount. For example,
Well, that's what happens is, if I may, for company A, it may be 10 lakhs. For company B, maybe 25 lakhs. For company C, it will be different. So these are different figures for different companies.
Ordered to be paid by the commission.
yes,
Or but in installments.
and they have paid it.
Now, what had
except for
happened for that period is, my lords, why the grievance before your lordship? From April 2024 till October 2024, bills were raised, my lords, we paid the entire amount. There is no dispute for the power that we consumed, we paid it. Now, in 24th October 2024, the commission says, no, the bill should be at this rate and not this rate. So, therefore, the question of this tariff differential amount. It's not that, my lords, I've consumed power and I've not paid. Whatever they billed
No,
me,
in
I've paid
respect
for it.
of this total due,
My lords.
4.23 crores.
In respect of petitioner number 1, my lords.
No, all the 4 companies
Well,
together.
423.
How much you can pay now? And
Well,
case-
they have all paid. We have also
No,
paid the
it's
first
due.
installment amount in respect of petitioner number 1 before your lordships in this appeal. We paid 50 lakhs. I am praying, my lords, may hear us immediately and, my lords, decide
no,
this
but
entire issue.
in respect of the other companies,
They have paid, my lords. As a matter of fact, the last payments is all reflected over here.
no, but still 4.23 is due.
My lords, 4.23 comes only because of that first company. There, the due is 350. Rest are, my lords, is 36 lakhs, 21 lakhs, 15 lakhs. My lords, that's not a difficulty. If your lordship so direct, they'll pay it within 2 days. I am only praying, my lords, before the next installment becomes due.
the installments are 7 installments are already
No,
due.
installment would be only the current installment.
My lords,
According to them, the past
my lords,
is
if I may just make a my lords,
no, out of the arrear, how much you can pay without prejudice to rights and contentions, and keep on paying the current.
current we are paying in any
Current
case.
is 35.
No,
current is, my lords, on
as
consumption.
per consumption, my lord. As
On
per
consumption.
on consumption. Whatever
As a
they've
matter of
been-
fact, the petitioner number 1, my lords, he paid 3 crores 15 lakhs for the current bill on 31st. My lords directed pay another 50 lakhs. We've paid that also towards the differential amount.
because current to they, in any case they
I'm
have
only
to pay.
praying, my lords, if it is not inconvenient.
They still say that 3 lakh 50 is due after giving credit to 50 lakhs.
Right, 3 crore 50 lakhs is due.
What I'm only praying is, my lords, the alternative argument is there was an interim order of stay from January, my lords. If, my lords, the order has been vacated in June, the first installment becomes due in, my lords, July. That we've already paid. I'm praying before the next installment is due, my lords may hear us on the appeal. There's a short point involved.
My lord-
And my lords may dispose it of.
That may not be possible for the court always. We make solemn promises, but often unable to keep.
My lords,
That-
I'm only.
you do one thing as far as this area is concerned.
My lords.
You pay it off at the rate of 50 lakhs per month over
My
7
lords.
months.
My lords.
Because, my lord, what has happened?
This is the same thing with
Because
my lords. I'm grateful.
current
My lords
dues-
have appreciated it.
Correct.
27th it was stayed. The tariff difference, my lords. Now the orders got vacated in the month of June. So, my lords, even if it flows one installment we've paid, the next installment, my lords, will again be due. We'll pay it.
My lord, the issue is, my lord, what the problem which we are having, my lord, that in any case, current dues, whatever they are consuming, they have to pay. That is under the Electricity Act. There is no issue on that.
They will pay current, but the arrear is
Arrears, my lord, Commission directed them to clear the arrears from December last year, my lord. And in between, they have.
Even if it is December, my lord, we have time till September.
Thrice, my lord, they have gone to the court in writ, in review, and after disconnection. Disconnection was also dismissed by the single judge, my lord, and there is no challenge. Now, all companies had paid, my lord, except Pioneer. Pioneer have not paid,
They have now paid, you have recollected.
And only 50 lakh rupees have been paid out of 4, because total amount due to Pioneer, if you also will see third column, 5 crore 14 lakh. So in 5 crore 14 lakh, they should have paid by June 4 crore rupees, my lord.
All right.
So they have not paid this.
Mr. Advocate General, if you succeed in the writ,
Yes, my lord.
if you succeed in the writ, this amount which they are paying ad hoc without prejudice will be adjusted towards your tariff demand.
Arrears.
Yes, and if they succeed in the writ, if they succeed in the writ, it will be credited towards their future dues. Adjustment will be given.
The problem, my lord,
There is
that
no difficulty.
No, because
We are agreeable.
my problem is that these are the tariff orders. If I give concession to one, all of them will say that give me the arrears. I will not
others
pay
have
installment.
all-
Because my lord, I have been reeling under financial crisis for last so many years. They come to writ court. They said matter is pending. Please give me stay. They get the stay, and I am not getting the dues because I have already spent
lord,
money on that.
I am
Not
not
for
simply
whatever
saying.
reason, the court has not sent you to the alternative remedy forum. The court has retained the matter. Now, once the court has retained the matter, the court has to decide now
Yes, my lord.
whether it will take it up or not.
I see what is falling from your lordship.
And in the meantime, some payment for electricity consumed.
My lord, so the only issue is that these are the industry. For example, what has happened, my lord, Sham Sanctuary was also party before the London Civil. 7 crore rupees was due. It did not pay because of the interim order. It did not pay single amount. Now it is asking for permanent disconnection because it is saying that I will generate my own power and give me permanent. So we will be starting a process of recovery.
Up to now, Mr. AG, you got nothing. But virtue of our order, you have got 50 lakhs.
From Pioneer, others we have got
Yes,
money.
we
my
will
lord.
order that.
Others we have got money, my lord. And secondly, my lord, they are enjoying the certain benefits of tariff order, my lord. Tariff order says that if there is a fluctuation in price, you pass on the benefits. We are passing on the benefits to them and they are realizing those benefits. They are,
that's
on
for
one
the
hand,
future period,
they are
right?
using the benefits under tariff order. And second, when the tariff order says you make the payment, you are not making the payment.
There
my
are
lord.
two parts to this tariff order. I don't know why my learned friend is
Tariff
confusing
orders,
that.
these are the,
We are
my lord,
saying
kindly
it comes
see
into
the-
effect.
Both of you argue at the same time, it becomes very difficult for us.
But I'm simply saying it comes into effect from
in my
24/10.
humble submission, they do because.
My lords,
and third point, my lord,
my lords
one
may
more
hear
point.
us finally in appeal, my lords.
Yes.
One more point, my lord. So far as this order, they went to the learned single judge against disconnection. Learned single judge dismissed their writ petition against disconnection, my lord, and there is no challenge, my lord.
There is.
So
It is on
there
the way,
is no
it is coming.
challenge, and therefore, my lord, the order of learned single judge, so far as disconnection is concerned, it is standing against them, my lord, and there is no stay also, my lord. This, if your lordship will kindly see, I just wanted to place that order because they have not filed the order. They filed the order after the filing of writ of appeal. Kindly see page 12 of the additional affidavit, my lord. Kindly see this order, my lord. And learned single judge has narrated how they have been trying to
Let's see if
hoodwink
with
the
all-
entire legal system.
my lords,
Kindly see.
These expressions are absolutely not called for. That's not the finding of the learned single judge.
I will show page 14, my lord. Kindly see.
I'll be thankful if my learned friend can show me this expression.
Paragraph 5, my lord, page 15. Page 15, paragraph 5. From the submission and perusal of impugn order of 6/6, it is seen that said notice of demand for outstanding dues has been made after court has disposed of on 339 of 24 and 9 of wherein certain tariff order had been challenged and also jurisdiction of MACRT to issue order of recall. As such, it is not a fresh matter or simple situation where non-payment of dues without due process disconnection has been effected. A perusal of the impugn notice of 6/6/2025 clearly mentions circumstances in which same has been issued. A further period of 15 days from the date of issuance of notice has been allowed for full payment of outstanding amount. From the averment and statement made in para 7 of writ petition, it is noted that power supply to respective plants were disconnected on 22nd July 2025 2025, that is well over a month from the date of said notice. As such, it is not understood under what circumstances writ petitioner are selling the impugn notice, as even section 56 mandates only notice of 15 days. Looking at the instant matter from all angles, especially the fact that impugn notice is the culmination of multi-party litigation over a period of time, coupled with the fact that even after writ petition number so-and-so has been disposed of, appeals and even review have been filed therein. Initially, order of history of disconnection has been passed. The prayer for interference of this court at this juncture amounts to non-adherence to section 56 is unsustainable. Further, even the ground of maintainability writ petition is clearly disabled in as much as there is no authorization of the deponent to so-and-so except on the respondent number so-and-so. So even section 56 has been taken into account.
Certain expressions are absolutely
and this order is not challenged. This order is not under challenge before. This is not part of the
any
appeal.
orders passed
From
that was
two leading counsels of this court, submissions at the same time is a little surprising. I am taken a little by surprise. Why won't you have confidence in the court?
I'm sorry, my lord.
I bow down.
This cross submission is made at the same time when there is lack of confidence in the court that will soon be overpowered by the other side.
Absolutely not. I bow down.
This is a sign of anxiety.
I bow down.
And that is
Okay, please take down. Please take down. We formally admit all the appeals. Paragraph. Further to our order dated 7th August 2025, the electricity supply of the appellant Pioneer Carbide Private Limited was restored on 8th August 2025 upon their making payment of rupees 50 lakhs to the Meghalaya Power Distribution Corporation Limited in terms of our said order. Paragraph. As the same points are involved, we propose to hear out the other appeals, dispensing with all formalities. Advocate on record for the appellant in each appeal shall file an informal paper book in this court by 12th September, serving a copy thereof on the advocate on record for the respondents. At least 7 days before the date fixed for hearing of the appeal. paragraph. In these appeals, 4 consumers are involved, namely these 4 in green. A, side by side. From a chart handed up to this court by the learned Advocate General, the due of pioneer after adjustment of the said payment of rupees 50 lakhs as on 31st July 2025 is 3,50,04900.37, comma, of RNB carbide (36), 47, 100.05 as on the same date, comma, of Green Valley 21,46, 248.71 as on 7th August 2025, and of RNB Cements 15,81, 676.82 as on this same date. Full stop. This claim of the licensee Meghalaya Electric Corporation Power Generation Corporation Limited is disputed by the writ petitioner appellants and the entire issue is the subject matter, would be the subject matter of the appeal. Mr. Paul Lonnet, Senior Advocate, appearing for the said electricity consumers, submits that RNB Carbide, Green Valley, and RNB Cements have been making payments of their electricity consumption. Full stop. Only Pioneer Carbide Private Limited had not made payment before making payment of rupees 50 lakhs, as there was an interim order of this court in the application for review in respect of the in respect of the judgment and order dated 2nd June 2025 disposing of the writ application, where the court had directed the licensee, said licensee, not to disconnect electricity supply. However, all current demands of the said licensee are being paid by or shall be paid by each of these 4 companies. Paragraph. As far as the alleged area of rupees 4,23, 79, 925.94 is concerned, each of the 4 companies shall pay their respective areas, enumerated above, in 7 equal monthly installments commencing from 1st September 2025 and payable by the 10th of each month, full stop. Each of these 4 companies will continue to pay the current demand, paragraph, on fulfillment of these conditions. The electricity connection of Pioneer Carbide Private Limited shall continue to be maintained, and those of RNB Carbide, Green Valley and RNB Cements Private Limited shall not be disconnected. Full stop. In default of any one installment by the appellants, liberty is granted to the licensee corporation to apply to this court for vacation of this interim order and for leave to disconnect electricity supply.
The payments made will be without prejudice.
Yes, the above payments shall be made and received without prejudice to the rights and contentions of the party.
May I just pray for
Only
this?
one point, Milord. It's fine.
My
Milord,
learned
2,
preference.
3, 4, Milord. My friend has said that they will pay. So 2, 3, 4 are paying the installments, Milord. They have only some due is there. If your Lordship will see the chart. So far as 2, 3, 4 are concerned, Your Lordship, they have been paying, only some amount is due.
Whatever is due, they will pay in 7 installments.
Because
That's it.
2, 3, 4, and then we have the another installment due in July because if Your Lordship will see, total amount due is 12 crore rupees. 12 crore 14
Lords
lakh.
have clarified the original figure.
12 crore 14 lakh
We
54,500.
have gone by this, Mr. AJ.
This chart only. If Your Lordship will see, this chart is only because 9 installment will run from December 24.
That
So
is-
9 installment and total amount due, if Your Lordship will see, third column is 12 crore 14 lakh 54,000 501. And this calculation is till June is, my lord, 9 crore 44 lakh 64,000. So they have to clear the balance amount also. 12 crore rupees is total amount due, out of which 9 crore rupees was the due till June, out of which 5 crore 20 lakh 84,000 was paid. Then it became due 24 crore 23 lakh rupees, my lord. So major amount due is from Pioneer. Other companies are paying, my lord. There is no problem with regard
We
to other
continue
companies.
to
So, at the end of it, 10th August 2025, second last column.
Yes, my lord.
Yes.
So the due of Pioneer comes down to 350,
Yes, my lord.
and of the others of 36, 21, 15
Yes, my
lakhs,
lord. Because they have paid
aggregating to
the-
4.23.
They have paid the amount.
So why should we take the June? Why should we take the June figure?
So because, my lord, we have raised the bill because as per MSCRC, we have raised the bill in June. Bill is raised in July, my lord. So that is why we have raised the bill.
No, but
till
you're
June.
yourself saying 10th August, this is the due, 4.23.
Yes, my lord. So this is all in respect of June bills, my lord, in arrears, my lord. July, August, September, because they have to pay that.
If I
amount.
may, Millards, this chart is anything but Millards,
And this is the amount which they
pointing
have
out
to
the
pay.
correct position.
This is the amount
I
they have to
have
pay.
wanted to take liberty to point out the exact figures, Millards, because in some cases the installment amount is only about 16 lakhs. Very well, my lords have directed 7 installments will pay that.
Because if they have been paying, because only 2, for example, my lord, if in R&B carbide, they have to pay only 3 more installments. Out 6 they have already paid, my lord. Problem is with the
My lords,
Pioneer.
if your
only.
lordships permit, we can come back with a detailed chart with the breakup of each individual company. Another problem as well as they've given only in respect of 4. There are 7 appellants before my lords.
My lord, they have not challenged the tariff order, my lord. Even except Pioneer and Mather, they have challenged the tariff order. None of the companies have
No,
challenged the
item
tariff
number
order.
All right, one minute. At the close of submissions, Learned Advocate General submits that the said chart did not include the arrears for June and July 2025, right?
July and August.
July and August.
July and August 2025. Full stop. Let the appellants pay the arrear and current amount as per the above chart referred to. Leave is given to the respondent corporation to take out a formal application
Yes.
to claim any arrear amount.
Grateful.
Yes.
Great.
To claim any arrear amount.
I had a small prayer, my lords, before my learned friend came in. My lords have directed it on the 12th of September.
Yes.
We could have the paper books completed by next week. May I pray, my lords, if it's not inconvenient, if the matter can be taken up, listed on the week starting 25th, we can make an effort, my lords, because it's a small limited issue. We've taken sufficient time of this honorable court, my lords, on 2 occasions. We'll ensure, my lords, the paper books are served well in advance, my lords, in the course of the week itself. My learned friend would have next week, my lords, and if not inconvenient, my lords, may we make an effort for the week starting 25th.
If he agrees, then.
My lord, only problem, my lord, I would have agreed with my learned friend, my lord. What has happened, the presidential reference has been fixed for physical hearing by Honorable Supreme Court commencing from 19 on day-to-day basis. And there is no VC hearing permitted. And there is a hearing on 27th and 28th also, my lord. So,
We could have a
and
big
all
effort
states
on
are being
25th or
represented by-
26th.
Paper book by when you can file?
I can file it, my lords, today is the 12th. We'll file it by 18th. I can have it filed by 18th, my lords. Or if your lordship so direct, we'll file it by 14th. By 14th, we'll ensure the paper books are supplied, my lords.
Make it 18th, list on 28th. Then always according to convenience.
Yes, I'm grateful. my
For
lord.
flight.
Grateful.
By then, my lords, the charts can also come. We'll
Yes, and
have a
also
form.
like Advocate General also submits that the point of maintainability of this writ application has not been decided by this court and should be kept open in this appeal.
I am grateful.
Well,
I am grateful. Highly obliged.
Highly obliged.
Number 9.
We rule that the point of maintainability shall be decided during hearing of the appeal in accordance with the law.
My lords.
I am grateful.
This, Mr. Papa, you send with the order.
I had concluded my submissions yesterday. My learned friend Dr. Mosika and learned senior counsel Mr. Mishra. This is that judicial officers matter. My lords.
Yes, yes. Item 7.
Item 9, my lords. 1 to 8 are all connected, my lords. This is item 9.
Yes, Mr. Muzika.
My lord, more or less I have also submitted on facts, my lord. Only I wanted to place two decisions, my lord. Two judgments I wanted to place. In fact, these judgments were placed over the learned single judge also, my lord, and these are recorded. Well, I have submitted two compilations.
Yes, please.
But first, flag A, my lord. This is Sivanandan CT 24798.
Yes.
Or para 55 and 56, my lord. At internal page 824.
Paragraph?
Para 55 and 56. May I read? And in the next judgment, my lord, para 43, 44, and 45. My lord, in fact, the second judgment also deals with a more or less similar situation, my lord, where from the waiting list, my lord, the candidates were appointed. There was challenge to that.
Your waiting list.
50, the second judgment, my lord.
First.
First is not with regard to waiting list, my lord. But the second judgment is my lord. If I may just take your lordship to the second reason, my lord.
Second decision is the predicted.
Okay. (24) Volume 2 SCC 269, my lord. This is Vivek Kais versus State of Himachal Pradesh. Here, my lord, 8 vacancies were advertised. Subsequently, two more vacancies were announced, my lord, and from the waiting list, 2 more candidates were appointed, my lord. Lordship, kindly see para 43 and 44.
Yes.
So, my lord, these 2 decisions, in my humble submission, echo the views of your lordships, my lord. Your lordships have also expressed in similar line, my lord. That
That is all right. Mr. Mishra's clients cannot be unseated, as the first judgment has said.
Madam.
But then in these cases, there were no 2 vacancies arising immediately, as it is arising in your case.
my lord.
One now and one to arise in September,
One is arising end of this month, my lord.
end of
31st
this month,
August.
and one is existing.
One is existing. So, if lordship directs to create one supernumerary post, my lord, we will do that, my lord.
We will discuss the authorities and see what can be done.
Mr. Mishra,
But may I please your lordship? If my learned friend has finished, I'll just take very short time, your lordship. What you say?
We are not disturbing your clients. We will
My
not
lord.
be. That's all.
My lord, only one thing, because Mr. Paul has not given the consent. And tomorrow, if he goes to Supreme Court, then our argument will not be reflected in the judgment. That's the only hitch I have.
That
Because if he gives consent, I have nothing to say.
no.
Puts me in a very difficult position.
In
That's
any matter
my lord.
where a litigant is not affected by the court order,
My lord.
can be the subject matter of an appeal. And in the appeal, he might become affected, might not become affected. But as far as this court is concerned, we will not touch you.
Well, only thing, if your lordship permit me, I will just take your lordship's 10-15 minutes. Just give me that. Just to reply to what Mr. Paul has said, argued. Otherwise, I leave it to your lordship.
All right, you come. If that satisfies you, you come tomorrow. You come online tomorrow and finish the matter.
My lord. My lord.
or my lord, the matter can be kept CAB, my lord. Mr. can submit a written submission, my lord.
Let him be satisfied. Why?
Satisfied.
No, I am, my lord, your
We
lordship
cannot-
is satisfied. I am satisfied. I am not saying that. My only worry is tomorrow he'll go and say that I have not given consent and there is no argument from the other side. Private respondent. That's the only concern that I have.
This is not being passed on consent.
So therefore, your
It is not
lordship
being
will-
passed.
Then your
This is-
lordship may, if I may say, my lord, I will give points that I want to refer. Your lordship reflect it. That's all. Then your lordship may make it CB.
We are likely to say that upon filling up of the posts, there was some legitimate expectation of his participating in the next selection process and qualifying. And that is being denied by filling up from the waiting list. Now, that kind of a legitimate expectation is being fulfilled by existence of a vacant post and future existence in August or September of a post becoming vacant.
And we'll condone the age, my lord. If it's over age, my lord, we'll condone the age.
So far as legitimate expectation is concerned, my lord, I wanted to raise first on the first day when I said before your lordship on the locus. My learned friend, my lord, has referred to Prem Singh. And with all due respect, my lord, this has not been correctly read before your lordship. He read two paragraphs, 11 and 12. 11 contains the contention of the council. 12 consists of two parts. One, the Supreme Court says nothing. But the second part, the Supreme Court says about those who are going to become eligible under the rules subsequent to the selection process, notification of the posts. At that point in time, they were not, but subsequently they have become. So they have only right. And there is a Rakhi Ray case, my lord, versus High Court of Delhi. There, my lord, the Supreme Court has clearly spelled out who will be the aggrieved person. And there is a decision, my lord, of 1996 of Guwahati High Court Division Bench where I appeared, my lord, for the selected candidates. Only 32 posts were advertised and select list was made for 181. And there, my lord, challenge was made by unsuccessful candidate, and in that they say, my lord, that they have no locus. This cannot be struck down, my lord, everything on the basis of challenge made by the person who have participated and could not succeed in the selection process. These are the one or two decisions, if your lordship permit, I will just put it, and if it is on record, my lord, your lordship may pass any, that's your lordship's prerogative, I have nothing to say.
But you know the danger of, what if you know the danger of it being on record? You know the danger of those decisions being on record. His writ will be dismissed. He will go to the Supreme Court. The Supreme Court will say, as far as your clients are concerned, that no, don't take back their salary, but terminate their service, let them participate in the selection process, as they have done in West Bengal, that school teachers case.
School recruitment.
School teachers case I've seen. My lord,
So you want
anyway,
to take...
I'll leave it to your lordship.
No, leave it now. I am leaving it to you.
Your lordship may decide. I have nothing to say.
All right,
Lordship may make it CAB if your lordship is passing that order.
Yes, hearing concluded, CAB, advocates on record for the parties are at liberty to file written notes of arguments. By when, Mr. Mishra and Mr. Paul?
18th
tomorrow.
will file. The other
Day after
cases
tomorrow,
also
14th.
filed by
Monday.
By Monday we'll file.
Monday, 18th.
By 18th.
Yes.
Yes.
Highly flagged.
Number 10.
May we please, your lordship? Lordship, I beg to seek an adjournment since the conducting counsel is only for your lordship on health grounds.
What?
The conducting counsel is only for your lordship on health grounds, so I beg to seek for an adjournment, your lordship. My lords, I pray for 2 weeks' time, your lordship, if your lordship.
Your arguments were so formidable that it has affected his health.
Lordship, he had argued, I mean, the appellant had argued on facts.
Yes.
The facts part I had replied, and then I have given a brief note.
Nothing is there
Nothing
on record challenging the
Absolutely.
FIR or the
Absolutely.
162 statement. Nothing is there.
161.
Only learned senior advocate has seen the records. That is nothing.
Nothing. So only limited issue, your lordship. They may grant them adjournment, lordship. Only limited issue whether he wanted to
Tell us
rely.
when.
He wanted to rely on
After
some
2
law.
weeks, your lordship. After 2 weeks.
No.
My lords, my senior will be back after 2 weeks, your lordship.
Only on law points, your lordship. So
This matter has to be finished. But if he is not in proper health, you will do the matter.
Okay, Your Lordship.
All right. Hearing of this appeal is peremptorily adjourned till 26th August.
Obliged.
Right, Your Lordship.
All other matters are not there.
We will take the other matters tomorrow.
Lordship.
PIL matters will be there tomorrow.
Come on. Come on. तो मुझे